High Court has granted interim bail to former BJP leader Kuldeep Singh Sengar.
Today's day is extremely telling about where the scale of justice tilts in India.
सर उनकी कैंसिल की जाए, बेल खारिज की जाए, हमको उसी में न्याय मिलेगी, नहीं तो हमको न्याय नहीं मिलेगा.
The court, looking for a needle in the haystack to save Sengar, claims to have found one.
31-year-old Abhaya was brutally raped and murdered on the 9th of August.
TV actor Ashish Kapoor, arrested for allegedly raping a woman at a house party, has been granted bail.
Actor who has been charged with rape has just got anticipatory bail.
This is a huge blow to the pursuit of justice.
India's rape laws are among the stringent in the world. The punishments are severe. The definitions are wide, and yet, when the accused is politically powerful, outcomes change. This is a story of how laws are navigated, stretched, and exploited when the accused hold political power. Rape is defined under Section 375 of the Indian Penal Code. After the Criminal Law Amendment Act of 2013, the definition was expanded to include acts beyond penile penetration and to recognize sexual violence committed through abuse of authority or coercion. Punishment is prescribed under Section 376. For rape of an adult woman, the minimum punishment is 10 years of rigorous imprisonment, which may extend to life imprisonment. If the victim is a minor, the Protection of Children from Sexual Offences Act, that is POCSO, applies. Under the POCSO Act, rape of a child below 16 years carries a minimum punishment of 20 years, which may extend to life imprisonment for the remainder of natural life. In aggravated cases, however, including repeated rape or custodial rape, the law permits the death penalty. On paper, these are among the harshest and toughest sexual offense laws in the world. Procedure begins with the registration of a first information report. The Supreme Court has ruled repeatedly that an FIR registration in sexual offences cases is mandatory. Police officers who refuse or delay registration can themselves face disciplinary and criminal action. And after the FIR, the survivor must be sent for medical examination. Statements must be recorded under Section 161 of the Criminal Procedure Code. A magistrate must record a statement under Section 164. The police must file a charge sheet within 90 days, and the trial should then proceed. Well, this is the design. What the design does not account for is power and delays. The first legal loophole appears before the case even enters a courtroom, and this loophole is procedural discretion at the police level. Police control the timing, police control seriousness, police control momentum. The law assumes neutrality, but the political power or money power erodes it. The Unnao rape case exposes this with brutal clarity. In June 2017, a 17-year-old girl accused Kuldeep Singh Sengar, a sitting MLA from Uttar Pradesh, of abducting and raping her. Despite the gravity of the allegation and the involvement of a minor, the FIR was allegedly delayed. Police initially framed the matter as a dispute. During this period, Singer remained free. During the same period, the victim's father was arrested on unrelated charges and later died in police custody. The family alleged custodial assault. No court had yet ruled on the guilt, but the machinery of pressure had already moved. This delay was not a violation of black letter law. It was a violation of justice. Delay matters because sexual offense cases are evidence sensitive. Medical findings weaken with time. Witnesses are vulnerable to intimidation. Digital evidence disappears. Delay almost always favors the accused. Only after the survivor attempted self-immolation outside the Uttar Pradesh Chief Minister's residence did the case explode into public consciousness. That act forced intervention from the Supreme Court. The investigation was transferred to the Central Bureau of Investigation. the trial was moved out of Uttar Pradesh to Delhi. Witness protection was ordered and a fast-track court was established. This needs to be understood clearly. None of this was routine. This is the judiciary stepping in because the ordinary system has failed. In 2019, a Delhi court convicted Kuldeep Singh Sengar under Section 376 of the IPC and under provisions of the POCSO Act. He was sentenced to life imprisonment and he was also convicted in a separate case relating to a custodial death of the victim's father. For the public, this looked like justice delivered. Legally, it was just only halfway. The second loophole is embedded deep within the criminal procedure. This is the appellate structure. Every convicted person in India has a statutory right to appeal. During the pendency of an appeal, higher courts have the power to suspend the sentence. Now, suspension does not erase conviction, it just pauses the punishment. This safeguard exists to prevent irreversible harm if in case the conviction is later overturned. The problem is not the safeguard, the problem is time. India's appellate courts are overburdened. Criminal appeals often take 5 to 10 years to reach final adjudication. This is exacerbated by the overall court backlog in India with over 53 million pending cases, including more than 1 crore criminal matters, contributing to prolonged delays in appellate processes. The Supreme Court alone has approximately 80,000 pending cases. And during this period, suspension of sentence effectively becomes temporary freedom. In late 2024, the High Court suspended Kuldeep Singh Sengar's life sentence and granted him bail pending appeal. In a recent development on December 23, 2025, the Delhi High Court confirmed the suspension of his life sentence and granted bail pending the appeal, allowing him temporary freedom while the case continues. The conviction still stands, the punishment does not. Well, this decision followed existing law. It exposed the law's weakness. In Unnao, extreme public pressure forced extraordinary judicial intervention. Even then, appellate law diluted punishment. This is how powerful people get away. Not by breaking the law, by navigating it better than anyone else could. The data supports this reality. According to the National Crime Records Bureau of India, India records more than 30,000 rape cases annually. In 2023, approximately 85 rape cases were reported daily, totaling around 31,000 cases for the year. The national conviction rate for rape has consistently hovered between 25 and 30% over the last decade. Recent data from 2022 shows an acquittal rate of 65.14% in rape cases, with conviction rates ranging between 27 to 28% from 2018 to 2022. For 2023, the conviction rate remained around 28%. Furthermore, in 2022, there were 198,285 rape cases awaiting trial and only 18,517 were completed, underscoring the severe judicial backlog. This means that in nearly 3 out of 4 cases, the accused is either acquitted or the trial fails to conclude with conviction. These figures include ordinary cases. In cases involving powerful accused, the structural advantages are greater. Recognizing this imbalance, the Supreme Court in 2017 directed the establishment of special courts to fast-track criminal cases against members of parliament and members of legislative assemblies. These courts were meant to prioritize cases involving elected representatives, including serious offences like rape. Hundreds of such cases remain pending despite this intervention. As of 2024, there are 151 sitting MPs and MLAs facing cases related to crimes against women, with 16 charged specifically with rape under IPC Section 376. Among these, West Bengal tops the list with 25 such lawmakers, followed by Andhra Pradesh with 21. This reveals another layer of loophole. Even when special mechanisms are created, they rely on the same police, the same prosecutors, and the same institutional ecosystem. Political influence does not need to enter the courtroom. It operates before that point. Police answer to state governments. Prosecutors are appointed by governments. Transfers and postings depend on political discretion. None of this is illegal. All of it just shapes the outcome. Then there is endurance. Criminal trials in India are long. Appeals are longer. Legal battles require money, safety, and emotional stamina. Most victims cannot fight for 10 years. Politicians can. Consent law adds another layer. Courts still evaluate consent through conduct. Delay in reporting is questioned. Continued contact is misinterpreted. Fear is treated as ambiguity. The law asks why the woman did not leave. It rarely asks what leaving would have cost her. That question does not exist in a statute. The absence is itself a loophole. What emerges is not a conspiracy, it's a structure. A structure where procedure overweighs context. A structure where time favors the accused. A structure where power controls the institutions. A structure where appeals dilute punishment. A structure where silence becomes survival. By the time a verdict arrives, the damage is complete. The law promises justice, the process delivers exhaustion. And in the space between promise and the process, power survives. That space is the legal loophole.